Sure thing. Okay. Go right ahead.
First case is Thompson School Road Neighborhood Association et al. v. Knox County, Tennessee et al.
Thank you. And for the appellant, have you already reserved your time for any rebuttal?
Yes, Your Honor.
And then how many arguments will we be having from the appellees?
There will be two of us arguing, Your Honor, the appellate.
Have you already divided your time?
We have, Your Honor.
Okay, and who's going to be doing what?
I'll go about 10 minutes
Okay.
on behalf of the individual defendants, and Mr. Moyers will go about 5 minutes on behalf of the county.
Okay, thank you very much. Okay, if there's nothing further, you may proceed, yes, sir.
Thank you and good morning, Your Honors. Daniel Sanders here on behalf of Thompson School Road Neighborhood Association and the other appellants. May it please the court, Thompson School Road Neighborhood Association filed this action challenging a rezoning decision by the Knox County Commission. The trial court granted summary judgment to the defendants, and the plaintiffs have now appealed, raising 4 issues. The first is whether the Knox County Commission rezoning decision violated the statutory requirement that zoning decisions be consistent with the adopted sector plan. In this case, it's the Northeast County sector plan. Alternatively, the appellants challenged the rezoning as illegal because the commission relied on incomplete and incorrect legal advice, which led members of the commission to discount valid objections that were raised at the meeting. Intertwined in these 2 issues is whether the trial court correctly interpreted the consistency requirement, and lastly, whether the trial court erred in granting summary judgment. The facts of the case, the main issue here is zoning density. The policy plan applicable at the time permitted rezonings in the rural district at a density of up to 3 dwelling units per acre, and the provisions of the growth policy plan appear in volume 3 of the record, pages 303 through 313. The Northeast County sector plan is part of Knox County's general regional plan, adopted pursuant to Tennessee Code Annotated 13-3-301. The sector plan appears in the record at volume 3, pages 326 through 341. The Northeast County sector plan includes a table entitled Appendix B, Land Use Classifications, that lists the description, location criteria, and recommended zoning for each proposed land use classification. And that specific table appears volume 3, page 340. That table contains a recommended zoning program for property designated rural residential in the Northeast County sector plan. It states that, and this is a little bit hard to read, but it says, in the county's rural area, the recommended zoning program is open space, OS, E, estate, RR, rural residential, a new zoning with densities of 1 dwelling unit per acre or less, or PR at densities of 1 dwelling unit per acre, where dwellings may be clustered in one area of the proposed subdivision. Now, those are the recommended zoning programs. There's also a part of the table that says
These are recommended. This is the recommended zoning. Will
Yes.
that supersede the growth policy plan?
No, Your Honor. In fact, there's the separate provision in the state law that requires land use decisions to be consistent with the growth policy plan. But the subsection that we're dealing with here, 13-3-304, requires land use decisions to be consistent with the sector plan, which is, in this case, a part of the general regional plan. We would argue, Your Honor, that zoning decisions or land use decisions that must be consistent with both the growth policy plan and the sector plan or general regional plan. And we argue here, Your Honor, that the rezoning decision was not consistent with the Northeast County sector plan. That land use table It sets out recommended zoning programs. It also provides for other rural under the growth policy plan and rural residential under the Northeast County sector plan. The problem with the rezoning is that the County Commission rezoned the property at 2.9 dwelling units per acre, and that we argue that that is inconsistent with the recommendation that rezonings be limited to 1 dwelling unit per acre. And it's clear across that table that the maximum zoning that the sector plan recommends or that the County Commission should consider is 1 dwelling unit per acre. So there was some discussion about this at the County Commission meeting. Kevin Murphy, who appeared on behalf of Gibbs Planning Advocates as a planning advocacy group in Northeast Knox County, raised an objection to the proposed density. He specifically argued that the density of 2.9 dwelling units per acre would be inconsistent with the Northeast County sector plan recommendation of 1 dwelling unit per acre. Record, volume 3, page 312. And if I can read part of that, section 3.5 of the growth policy plan was the applicable provision. That provision reads, extensions of low-density residential development, densities of 1 to 3 dwelling units per acre into the rural area shall be limited to the following circumstances, and it imposes a condition for, it's got to be zone PR, it's got to have water and sewer, it's got to have roads, and then there has to be a traffic impact study. Now, if we compare the provisions of the growth policy plan, to your point, Your Honor, that are permissive, that allow extensions of low-density residential of up to 3 dwelling units per acre into the rural area with the provisions of the sector plan in this case. The sector plan, it's not permissive. It says, these are your recommended zoning classifications for this particular land use designation, future land use designation. And it says not only here are the recommended zoning programs of up to 1 dwelling unit per acre, here are other zonings that you might consider in this land use designation, and those other ones that you consider are also limited to 1 dwelling. In fact, does limit those densities to 1 dwelling unit per acre. So where there are 2 consistency requirements, you have one for the growth plan and you have another statutory consistency requirement for the general plan and the sector plan. To harmonize those things, we see that there's nothing inconsistent about the sector plan limiting density to 1 dwelling unit per acre, knowing that the growth policy plan only permits certain activities, certain densities. And where one is very general and the other is more specific to a piece of property or to a part of the county, we're not arguing, Your Honor, that the specific provision should control over the general provision. We're arguing that those two are in fact consistent with one another, and that the more specific requirement in the growth or the general plan or the sector plan does dictate that density should not exceed 1 dwelling unit per acre in that area.
Mr. Sanders, I have sort of a general question that may not necessarily apply to this specific case, but in general, when you see property that's currently zoned rural residential, where it's, according to you, limited to the 1 dwelling unit per acre, and then it's seeking to be rezoned to allow more units per, I mean, is that the typical, I'm just thinking about subdivision growth in Knox County as a whole. And my concern that if the language is read as you...
Rural area, and we would argue, Your Honor, that the rural area regulations or the rural area would control here. And the sector plan says in the rural area, here are your recommended zonings. It's limited to 1 dwelling unit per acre. I would, just with my last 15 seconds, I would say here, because the executive director said that the growth plan was controlling, that's not true, Your Honor. And I think that the county commission was misled by that.
Well, before you leave that, have the county commissioners received staff, professional staff input on this as to what will be acceptable in an area?
Right, Your Honor. They do, and Ms. Brooks is the executive director of the Knox County Planning Commission. She advises the county commission on these matters. She did not advise the county commission that of the appropriate legal rule, which would have been your decision has to be consistent with both the general plan or the growth policy plan and the sector plan, right? And if we were to go through that analysis, Your Honor, we would see that a rezoning at 1 dwelling unit per acre would be consistent with the growth policy plan, which permits more density, but it doesn't require more density. 1 dwelling unit per acre would also be consistent with the density recommendations and the other zonings to consider in the rural residential land use classification under the sector plan. And because 1 dwelling unit per acre is consistent with both of those things, and 2.9 dwelling units per acre is inconsistent with the sector plan, and I think by any definition, almost 3 times the density recommended or to consider would be inconsistent with that sector plan.
And the last question I have is if the sector plan is followed and required to be maintained, wouldn't that be no growth in the area at all?
No, Your Honor. As it is explained in the record here, this piece of property is 108 acres. It's just over the line. In fact, the line between the planned growth area, which we plan for growth in that area, and the rural area, which is aimed at keeping areas more rural, was right on this piece of property. And no, Your Honor, to answer your question, it doesn't mean that we won't have growth. It means that we'll have growth that's consistent with the sector plan. Thank you.
Thank you very much. You have your rebuttal. Yes.
May it please the court, my name is Garrett Swartwood, and I'm here on behalf of I-75 Land Partners and the HAM Land Partners, who are the appellees before this court, the defendants in the trial court, and with me is Michael Moyers, who is the attorney for the county, who will speak after I give some argument. The trial court should be affirmed in all respects in this case. It is our opinion, and we've argued in our briefs, that this case really hinges on the interpretation of a single word, and that word is recommended. That word appears in the general plan. Council referred to it as the sector plan, which is correct. I'll refer to it as the general plan. It does not appear in the growth plan, but it appears in the general plan. So the general plan provides that a recommendation, but it was only a recommendation. And that's the key to all of this entire case and to all the arguments that are being made by the appellant. So the appellant's making 3 substantive arguments. Council described them as 4, with the last one simply being that the trial court improperly entered summary judgment. But the 3 substantive arguments are that the decision of the county commission was inconsistent with the general plan because it recommended 1 unit and the county approved 2.9 units per acre. The second argument is that the county commission received inaccurate advice from the executive director of the planning commission, Amy Brooks, who said that the growth plan is controlling. And then the third issue is just generally that the trial court failed to view the evidence in the light most favorable to the appellants. But each one of those arguments hinges upon a fairly novel and unusual interpretation that the appellants are giving to the word recommended. The appellants are interpreting that word to mean required. Resolution or ordinance, the same way you would interpret a statute, namely that it ought to be interpreting the words in their ordinary and usual meaning. And the ordinary and usual meaning of the word recommended, excuse me, if you refer to just Webster's dictionary, is giving advice. To recommend is to advise, to suggest, to counsel. It's not to require, as the appellants suggest. The court should appreciate the context in which this advice or this suggestion is being given. So the county commission is making decisions on unique property when they come up for application for rezoning. Every property is unique. And so the county commission is exercising a legislative function to decide the rezoning for that particular property. Some properties may have more infrastructure going to the property. Some properties, as council says, may be on the edge of a rural zone, but not deep within the rural zone. Some properties may have proximity to schools. And there's various factors that the county in its legislative capacity should consider. And that's why the general plan doesn't set forth a hard and fast requirement for density. It only provides a recommendation for density. The plan itself in other places describes its provisions as guidance for the county commission. So it's guidance for the county commission in making these legislative decisions on a case-by-case basis as each property comes up through application. So the court should also consider that the general plan is consistent with the growth plan. And I should compare the growth plan by contrast, by the way. So the growth plan does not use the word recommend. The growth plan uses the word shall. And it says that in this particular zone, the planned residential zone, the zoning shall be 1 to 3 units per acre based upon certain conditions. There's no argument in this case, there's no dispute that those conditions exist. So the range of density allowed by the growth plan. And for that reason, council's suggestion that the court needs to go into some interpretation of general versus specific provisions is not applicable. There's no ambiguity that needs to be interpreted by this court using that canon of construction. These plans are clear on their face and they're compatible with each other. Now, this court has heard a similar case before in the case of Benson versus Knox County, which we briefed. That was a case from 2016 in which the same issue was raised. Benson's a fairly complicated case, but one of the issues that was raised in the case was whether the density allowed by Knox County for certain sloped areas of a development were consistent with the general plan, which had provisions for density levels. The county had approved density higher than what the general plan provided. And the question is, was that consistent? So in that case, there was the plan itself did not use the word recommended, but it had been amended, and the amendment described those provisions of the plan dealing with slope densities as being recommended or being advisory in nature. So the recommended word came through an amendment. In our case, the recommended word exists in the general plan itself. But they're similar because both in our case and in the Benson case, there's express language that provides that the density provision is recommended and it's therefore non-binding and only advisory. Now, the court in Benson did not rest solely on that amendment. The court also considered that the county local officials had previously interpreted their own general plan as being non-binding. And that's a case that exists here as well. The evidence before this court and before the trial court, especially in the declaration of Amy Brooks, was that the staff, the planning staff, has interpreted the word recommended to mean just that, recommendation. And the staff has in the past recommended densities either higher or I guess maybe in some cases lower than the density provided by the recommended amount in the general plan. So you have both express language saying that it's non-binding, that it's recommendation, and you have prior interpretation of the general plan, and those are both conditions that exist in our case, and those are both conditions that existed in the Benson case. And the Benson case decided that because it was merely a recommendation for a certain density level, when the county varied from that recommendation, it was not being inconsistent in violation of the statute. Specifically said that the prior interpretations and applications of the plan in that case as non-binding and advisory must be afforded great significance by the courts. And the appellants would argue, well, you don't have to give total deference to the county if the county is acting illegally, but the court should give great deference to how the county has interpreted the word recommended in this case. And the county has interpreted that word to solely mean that it's advice, it's something the county should consider on a case-to-case basis, but it's not a requirement or a mandate or an obligation that the county has to follow. Now, I'm running out of time to let Mr. Moyer speak. I want to briefly address the Amy Brooks issue. So the appellants argue that Ms. Brooks, who's not a lawyer, she's the the executive director of the Planning Commission, told the county commission that the controlling plan was the growth plan. Well, she was right. The growth plan is controlling. There's a staff requirement of the growth plan. And so she was correct in her statement. But I would also point out she was not a lawyer. There was plenty of testimony given at the meeting by Kevin Murphy, who was a well-known advocate, who argued that the county commission should follow the recommendation of the general plan. So the county commission was provided advice on both sides of this issue and was given a full opportunity to consider these issues. So finally, let me just emphasize that this is legislative action. It's not administrative action. It's not quasi-judicial action that the county commission was taking. It was acting in a legislative function, and this court has repeatedly emphasized giving great significance to the determination of these legislative decisions. And I'll let Mr. Moyer talk a little bit more in that regard. Thank you.
Good morning, Your Honors. Mike Moyers for Knox County. I just want to emphasize something that my colleague touched upon in the short time I have left here. It is a long-standing rule in the state of Tennessee that in these zoning matters, the courts give great deference to the interpretations of the local zoning entities. Going back at least 32 years with the case of Whittemore versus Brentwood Planning Commission, the court stated, the meaning of a zoning ordinance and its application to a particular circumstance are, in the first instance, questions for the local officials to decide. Because I don't have a lot of time, I would say to the same extent, the State XRL Moore versus West, which is 246 Southwest 3rd, 569, and of course the Benson case, which has already been discussed here. Now the reason I want to bring this up is because in this particular case, we had 3 levels of local officials looking at this language that Mr. Sanders relies upon, this recommended language that's in that appendix. First level is the Planning Commission staff. They are the professional full-time staff members. They draft the language. They're the ones that wrote it, right? They looked at this language and came to the conclusion that 2 units, the Planning Commission did that. They approved this language, they sent it on to commission. They looked at this language, which they approved, and they came to the conclusion that 2.9 acres per or 2.9 units per acre would be the appropriate density. Looking at the language that Mr. Sanders would suggest requires them to be 1, they found it at 2.9. And finally, we move to the county commission, the legislative body. They took the language, the recommendations from the Planning Commission, and they put it into action. They made it the law. And again, they looked at that law that they passed and they interpreted it as allowing them to do 2.9 units per acre. That's 3 different levels of administrative bodies that have looked at this language, the bodies that are responsible for drafting, recommending, and passing it, and they all came to a different conclusion than the appellants. And I think that that's significant if we're going to continue in the tradition of deferring, not of course completely abrogating, but deferring in the first instance to the local officials' interpretation. So the only way that Mr. Sanders' argument has any teeth is if this court were to interpret the word recommend, as Mr. Swartwood said, to mean shall to mean may use this recommended language. It was to give the local legislative body some leeway because, as was stated, all land, we know from land use contract law, all land is unique. Every land has its own special characteristics, and therefore the county legislative body reserved for itself the power to go anywhere from 1 to 3, 1 being the recommended, but under the appropriate circumstances, as it has not been disputed exist here, to go higher. If you have any questions, I'm happy to answer them. Thank you.
Thank you, Your Honors. Tennessee Code Annotated 13.304B1 requires zoning decisions to be consistent with a general plan adopted by a legislative body. The language that it uses is, if the legislative body adopts a general regional plan in the form of an ordinance by the municipality or a resolution by the county, then any land use decisions thereafter made by the legislative body, planning commission, or board. I think the requirement of the statute that I just read says that once the planning commission makes a recommendation with a regional plan, which we know the process, the planning commission adopts the regional plan, and then the county commission may, but is not required to adopt the regional plan or the portions of the regional plan that apply to the county. The statute, and this is why I would submit to the court that the important word here is consistent, not recommended. Where the legislative body adopts the general plan, those recommendations then carry a consistency requirement. And there's nothing in the law that says that a decision has to be more or less consistent with a recommendation than a requirement. I would submit to you that you won't find that in the law. So our position here is that whether the general plan contains requirements or recommendations or suggestions, those provisions, land use decisions thereafter made, have to be consistent with those recommendations. And here we have a recommendation for 1 dwelling unit per acre. We have other zonings that they may consider that are also limited to 1 dwelling unit per acre, and 2.9 dwelling unit per acre is inconsistent with that by any definition, whether it's a recommendation or a here. If you read the provisions of the general plan at issue here, it says extensions of low-density residential development into the rural area shall be limited to. It doesn't say it shall be one thing or another. It says shall be limited to. And there's when you view that in context of the recommendations in the general plan, we see that a recommendation in the general plan that says 1 dwelling unit per acre is entirely consistent with the growth policy plan. And in fact, if you read the 2 consistency provisions, the general plan itself has to be consistent with the growth policy plan. And so we would argue, Your Honor, that those recommendations contained in the general plan, that you have
Be the superior authority.
well, I follow, Your Honor. Yes, in some sense, the county legislative body is the ultimate authority according to the sector plan. But, and it happened in this case, Your Honor, the county commission did amend the sector plan, right? It changed the sector plan designation from agricultural to rural residential. But there's a process for doing that. An amendment to the sector plan has to go to the planning commission. Planning commission has to adopt it. It comes before the county commission. There's a public process there. The county commission cannot just by fiat say in a meeting where an amendment has not been noticed, we're going to change these recommendations to from 1.9 to 2.9. That is not a proper way to do that. And so, yes, in some sense they are the ultimate authority, but only when they follow the public process by which those amendments can be made, and in this case they did not. Your Honor, I'm out of time, and thank you.
Thank you both for your presentation. Your case has now been submitted to this court for resolution. We would seriously consider this matter and render an opinion within a reasonable period of time.